All right, today we're unpacking a seriously fascinating administrative hearing. It's an explainer that dives right into a massive battle over data, transparency, and exactly how far you can push a homeowner association record request. We're looking at a real, boots-on-the-ground case here, one that blew up into an intense 7-year conflict between a homeowner and her HOA over a mountain of accounting data.
So what actually happens when a homeowner and an HOA fundamentally disagree on how 7 years of accounting data should be delivered? I mean, it's a situation that highlights a huge tension existing in communities literally everywhere, right? On one side, you have this completely understandable demand for absolute financial transparency. But then, on the flip side, you have the defense of administrative burden. Is it just too much work? Well, we're going to look closely at the case of Ann Galpin versus the University Shadows Homeowners Association to see exactly where the law draws that line.
To help us make sense of all the procedural minutiae in this complex administrative hearing, here's our roadmap. Number 1, the HOA records dispute. 2, narrowing the scope. 3, the homeowner's case. 4, the association's defense. And finally, 5, the governing legal framework. Let's get right into it.
Section 1. The HOA records dispute.
So the key players in this dispute are Ann Galpin. She's a homeowner who has lived in the University Shadows condominium community down in Tempe, Arizona for 29 years, and the University Shadows HOA, who are represented by their attorney, Mark Lines, and their managing agent, Heywood Community Management. Let's trace how this relationship really hit a boiling point. Back in April 2025, Galpin made an initial records request. The managing agent partially denied it, basically saying, hey, we only need to provide 3 years of records based on our retention policy. Frustrated by that, Galpin went ahead and filed a formal petition with the Arizona Department of Real Estate in October 2025. That move triggered a pre-hearing conference in February 2026, which ultimately culminated in a formal administrative hearing in March 2026 before Administrative Law Judge Nicole Robinson.
Section 2. Narrowing the scope.
Now, when you enter an administrative hearing, you can't just throw everything at the wall and argue about everything under the sun. It doesn't work like that. Judge Robinson strictly limited the focus of this hearing to just 2 unresolved items from Galpin's October petition. They were known as Request Number 3 and Request Number 5. So what exactly were those? Well, Galpin was demanding a detailed general ledger, accounts payable and receivable ledgers, check registers for all open and closed accounts, and detailed vendor ledgers. And here's the real kicker. She wanted these records to cover a massive 7-year period, going from July 2018 all the way to September 2025. Oh, and she preferred them to be delivered in a continuous Excel or CSV format.
To really grasp the mechanics of this dispute, we kind of need to clarify some of the dense accounting jargon that kept coming up during the hearing. The homeowner heavily emphasized this concept of the general ledger. Based on her testimony, she views the general ledger as a central electronic repository. Think of it like a master digital environment where literally every financial transaction is entered as binary data, logged permanently with unique code and directly connected to source documents like invoices. For her, everything else is just a subledger pulling data from this one massive master database.
Section 3. The homeowner's case. Ann Galpin's perspective is built on a really deep conviction about how modern accounting software actually works. She argues that just handing over paper printouts or static monthly PDF files simply isn't enough anymore. Her stance is that digital data absolutely must be made transparent in a way that is easily searchable and chronological over that entire multi-year period she requested. The absolute crux of her argument is perfectly captured in her own testimony. She said 11601 says yes, you must convert digital records into a written form. Galpin argued that because HOA financial data exists dynamically inside a computer program, the association has a strict legal duty to convert or extract that binary data into a readable, chronological, written format, like an Excel spreadsheet, so it can be properly examined. Her core frustration really just boils down to fragmented statements versus continuous data. It's like trying to put together a giant puzzle where the pieces don't quite fit. The HOA had actually already provided her with hundreds of pages of monthly board statements and check registers. But Galpin testified that trying to examine individual pre-printed monthly statements was frankly non-transparent. She argued that it's nearly impossible to track, say, a check written in August but cashed in October without constantly flipping back and forth between all these fragmented pages. What she wanted was continuous 7-year Excel spreadsheets to easily track the flow of money from start to finish.
Section 4. The association's defense. Pivoting over to the HOA, represented by attorney Mark Lines, their position is incredibly firm. They fully and completely complied with the law, period.
Their argument rests on a very specific legal distinction regarding what a record actually is versus what a homeowner might simply desire it to be. The drama of the hearing really peaked during cross-examination when lines pressed Galpin with this incredibly pointed question, so what you're requesting is they generate that report for you. And that right there is the absolute core of the HOA's defense. They argued that they had already provided the existing records they maintain in the ordinary course of business. By asking for a custom 7-year continuous Excel spreadsheet broken down by specific vendors, the homeowner wasn't just asking for an existing document. She was demanding the HOA do custom data entry to generate a brand new report specifically for her.
So here we clearly see the fundamental disagreement at the very heart of this dispute. On one side, Galpin's argument is that digital records by their very nature must be extracted and converted into a readable Excel format to truly fulfill the spirit of transparency. On the other side, the HOA's defense is strict and literal. Associations have a duty to disclose existing records, but they have absolutely no legal obligation whatsoever to create new customized compilation documents that don't already exist in their files.
During that rigorous cross-examination, the HOA's attorney managed to secure several critical concessions from the homeowner. It was a big moment. Galpin had to admit on the record that she is not employed by the association, she's never actually been inside the management offices, she has absolutely no personal knowledge of how their specific software is maintained, and crucially, she cannot definitively prove that the specific 7-year continuous Excel ledgers she requested actually exist as standalone documents in their system.
Section 5. The Governing Legal Framework.
Now, Administrative Law Judge Nicole Robinson isn't making a decision here based on who is more persuasive or who gives a better speech. She is strictly evaluating the facts against the actual state laws and internal community policies governing condominium associations. The primary law governing this entire dispute is Arizona Revised Statute Section 33-1258. It states that financial and other records of the association shall be made reasonably available for examination. Now, what's really interesting about this statute is what it actually doesn't say. While it establishes a clear duty to disclose records, it does not explicitly dictate the formatting of those documents. And it certainly doesn't mandate that data must be exported into Excel spreadsheets the moment a member requests it.
Furthermore, looking at the management company's internal policies, Heywood Community Management has a strict, official records retention policy in place. It's important to note that while foundational documents, things like CC&Rs, are kept permanently, everyday financial documents like bank statements, contracts, and financial statements have a very strict retention period.
And that retention period is exactly 3 years. That single number highlights a massive logistical clash in this case. The petitioner fiercely demanded 7 years of continuous historical accounting data, arguing it would be, in her words, absurd to delete financial records. However, the managing agent's official legally adopted policy strictly limits the retention of those exact financial documents to a mere 3-year lifespan. This policy legally clears them of the obligation to keep the older data that she was requesting.
So we're left with a fascinating dilemma, and it's one that affects thousands of managed communities across the country. When we live in a completely digital age, full of complex databases and dynamic software, the very definition of a record becomes pretty blurry, doesn't it? So I leave you with this provocative thought to ponder today. In the pursuit of community transparency, where exactly does an HOA's obligation to produce an existing record end and the administrative burden to create a brand new one begin? Thanks for tuning into this explainer, and keep asking those hard questions.